Mr Chair, I rise in response to the comments made by the previous speaker and speakers previous to that. It's important to note at this point that the honourable member Andrew Little made about the restorative practices within the youth court and within our criminal justice system generally, which are being enhanced all the time, and obviously, as we all know, world recognised, because especially within the youth jurisdiction, they are world leading, and we need to be able to keep them up at that pace. And comments made around, for instance, derogatory messages given by some lobby groups against such things as restorative practices and restorative justice conferencing in particular. People suggesting, for instance, that restorative justice conferencing is more about the offender than it is about the victim. And what we know, of course, is that's absolutely incorrect. When we look, for instance, at the reoffending rates of those who have been through a restorative justice conference, when tested against a control of those who were willing and able to attend, but it was withheld from them, what we found was in community-based sentences where restorative justice was completed, there was about a 57% less recidivism rate, and where it happened behind the wire in prison, it was about a 34%. That was a study by Dr. Heather Strang of Cambridge University a few years ago. So it's interesting to note that the complete opposite is what is being put about by the likes of Sensible Sentencing Trust is actually true. Another point is that, as I understand it, and I've been made aware of it on a number of occasions, I don't know if the position has changed, but I doubt it, the President or the spokesperson for Sensible Sentencing Trust has been given the opportunity to attend a restorative justice conference anywhere, any time, and although saying he would, never has. I think it's a terrible thing when people operate within a sphere of ignorance, putting themselves out to be experts. In respect of the matters raised by the Honourable Phil Goff, I make the following comments. Firstly, over the time delay, all I can really say is that he will know, as well as anybody else, this government's been extremely busy, and the amount of legislation that it's passed through, all of it important. None of it blatantly out there to do things like win the next election, like the Electoral Finance Act that we had to put up with in the years gone by. But pleased to see that it has finally made its way to the House. And in respect of youth within the youth court jurisdiction, victims wanting to be represented within the youth court jurisdiction, and funding. When this government came into office in 2008, one of the first pieces of legislation we put through was the offender levy contribution, $50 for every offender appearing before the court to be paid, and that money to be used for victim services. And that money was used to set up a number of different initiatives, or to support a number of initiatives to support victims going through the criminal justice process. And so it is that money used for those purposes which will now be extended to victims within the youth jurisdiction as well. But there are a number of specific rights that are extended pursuant to this part, and the member will see, or will realise as I go through them, that a lot of them aren't expensive and will easily be met from within the funding that has been set aside for those specific purposes under the victim offender levy. The first right is to attend a family group conference. Well, an invitation is made to all victims to come to family group conferences. Whether or not they make themselves available for that family group conference largely depends on their own feelings towards that, and their feeling of safety, or feeling of really wanting to be in the room. And of course we're very sensitive about anything that could be seen as re-victimising a victim, a person who's already a victim. But the ability to be able to attend a family group conference and take part in that, along with their support people, is a right that's extended. Another one is to be informed about the services each agency provides, and their ability to be able to access the support of those agencies. If the offender is a child or young person, they also have the right to choose whether to be informed of the progress following the family group conference plan. So that's progress through that family group conference rather than necessarily the court process, which would also flow on automatically. Mr Chair,
Honourable Chester Borrows.
There is a right to choose whether the victim wishes to express their views, and they have a wide range of ability to be able to do that. They can make a victim impact statement. They have the right to express their views in other ways, as it's been mentioned by my colleague Paul Foster-Bell, which may not necessarily be in writing, and it may be difficult if that person is a very young victim, but to be able to do it by way of pictures or speech or other ways. The right to make a complaint if any person from agencies does not provide the service consistent with the principles of this particular code that I'm reading from at the moment. There is also additional rights for victims for specified offences, which might be sexual offences or serious assaults, and they include to be informed and express views on bail and other orders that may be sought or sought by prosecution or by offender. The right to read the victim impact statement in court, or obviously to have it read for them. The right to choose to become a registered victim, so go onto the victim's register for continued notification. The right to have a representative, to have and appoint a representative to receive information on behalf of that victim. The right to receive information and notifications after sentencing as to the progress of the offender through incarceration and future appearances before the parole board. The right to choose whether to make a submission to a parole hearing or in respect of extended supervision orders, and obviously the right to be able to attend and to speak and be heard in respect of those in those matters. And so it is just to allay the fears of the Honourable Phil Goff. The costs of this will be picked up by those services that already exist. In effect, it's extending the services that are within the adult jurisdiction down. Obviously, if there is a higher volume of victims requiring these services, then there will be an increase of costs. It's expected that that will be met within the current funding arrangements, and there's no suggestion that those wouldn't be met. Thank you.
Mr. Chair.
Carol Beaumont.
Very, very much, Mr. Chair.